Good morning. Uh, This is the second case for the second day of the July 2020 session of the Court of Criminal Appeals in Nashville. To my right is Judge Bobby Holloway from Columbia. To my left is Judge Tim Easter from Franklin, and I'm Tommy Woodall, and I'm from Dixon. I assume I've been saying this every time, but I think you're the only new person I haven't said it to. You're familiar with Supreme Court order about wearing masks in court buildings during court proceedings. The mayor had an executive order 8 about wearing masks. There is an exception in his order that's not a requirement if you're in a federal or state building, but we still fall under the Supreme Court's order. If you want to argue your case or remove your mask while you're arguing your case, we'll allow you to do that. You don't have to. You can leave it on, whatever, but if you take it off, we ask that you put it back on when you're not actually arguing or addressing the court. You are able to you'll be permitted to remain at the table and sit and argue instead of having to come up to the podium. Back in when we held court under these conditions in June, I don't think anyone came to the podium and argued, and it worked out just fine. We've had a couple of people come to the podium this session, and that's fine too. So whatever y'all want to do as far as that goes. If you do remain at your desk, I would ask that you adjust the microphone so that we can clearly, you may need to drop yours down a little bit or pull it towards you so that you can be clearly heard. This is being televised or videoed to the public by way of YouTube so that we comply with the constitutional requirement of having open courts. With that, I'll also mention that just for the record, everybody is socially distanced so that if you do remove your mask to argue, we will be in compliance with that. So are there any preliminary matters? No. Okay, would you call the first case?
State of Tennessee versus Janice A. Campbell.
And you have appellant has 20 minutes to argue, and each side does, and you can reserve some for rebuttal.
I'd like to reserve a little bit, Your Honor.
How much would you like to reserve?
Probably 5 minutes.
5 minutes, okay. You can proceed. You can go ahead and start.
Please, court, I am hearing impaired, and these masks don't help a whole lot. So if you have questions for me, I might not pick them up too good sometimes. So.
All right, you can. You don't have to stand up if you're going to stay at the table. It'll be easier for you to be picked up on the microphone if you sit down.
I'm used to standing up, Your Honor, when I'm in court.
Okay.
If I'm talking or whatever.
Would you like to come up to the podium or?
Oh, that'd be fine, Your Honor. Right.
Okay.
As the court knows, this is an appeal of a certified question of law, and I'm going to be fairly brief, and I think it's a fairly simple question. The question is whether the officer arrested the defendant unlawfully in violation of the code. And that was the question that we requested that we reserve, and I think the facts are not in dispute about how the arrest occurred, Your Honor. The officer received a call or dispatch about my client going to a liquor store. Apparently she and her daughter had some kind of argument, and so he knew who he was looking for and the type of vehicle, and he went to the liquor store, then went to the house to her house, and he was told that she'd gone to the residence around the mountain road. So during this scenario, he did know who he was looking for and knew where the defendant was going to be. And he arrived at Round the Mountain Road. She was in a residence talking with the people and visiting with them, and was seated in a chair behind the door. Other officers arrived there as backup. I think Highway Patrol was one and another deputy was the other. Anyway, officer had her come outside and proceeded to start conducting field sobriety test. It's our position that he did not fit, the arrest did not fit with any of the exceptions to a warrantless arrest or arrest without a warrant. The exigent DUI circumstances are investigating an accident or seeing her drive or a team effort where some other officer saw her drive. None of those are present in this case. So she was taken then after he said she did poorly on a field sobriety test, carried her into the jail and had her try to perform a breathalyzer test. And as a result of a health problem, she was unable to blow enough to get any kind of reading. So he carried her then to the hospital and had blood drawn. And what we contend is that she was unlawfully arrested, and therefore everything that happened after that would be unlawful detention and unlawful procedure. The officer agreed that the magistrate was available 24/7, that he could have gotten somebody to get a warrant because he knew where she was. If she tried to leave, he could have arrested her at that time. But they did not get a warrant. She was not free to leave, he said, until after he finished his interview, and then of course placed her under arrest and carried her in for the breathalyzer test. Now, all of that's in the record, and it's in our brief, and of course it's in what's been attached, and it's in up at the record. The court, in hearing this, we also filed a motion to suppress the blood test, but that's not the focus of this appeal. The focus of the appeal is whether the arrest itself violated the code and whether the officer didn't follow the code. The court thought that obtaining a warrant after the arrest at some point in time validated the arrest, apparently. And I think that's cited in our brief. I asked him if he, how many arrests that he'd made where he didn't see him drive for DUI, and he didn't recall any. And their procedure, his procedure, was always to arrest him and then take him in and then get a warrant. So apparently he'd never had an occasion to arrest someone for DUI who was in a residence that he never saw him drive, or anybody else, any other officer see him drive. There's no question that there wasn't an accident to be investigated. None of the other officers or anybody else saw her drive in law enforcement. And the officer did admit, and we cited on page 9 of our brief, that there was no extenuating circumstances at that time that he arrested her. And wasn't like stopping her on the road or anything like that. She was actually in a residence, and basically those are the facts. And of course, the court knows what the law says, and it's PCA 40-7-103, grounds for arrest by officer without a warrant. And it sets out the things that they can, that have to be present for them to arrest without a warrant. And the plea court opposition is none of those were present in this particular case. Thank you.
I have a question for you, sir. I did not see in your initial brief where you actually framed the certified question that you want us to consider.
I was looking in my brief, and apparently a page is missing out of mine. I didn't notice
Okay.
that till a while ago. That it should have been an issues page that we set out as page 1. Of course, it's in the order.
I have a
exactly what
copy
it said.
of the order, and it says whether the arrest of the defendant for DUI is in a private home without a warrant violates TCA 40-7-103 when the defendant was arrested without being seen by an officer operating the vehicle in question and no vehicle accident was involved. This issue would be dispositive. Is that your certified question?
That's a certified question. Yes, Your Honor.
You're aware that the state has said that's overbroad.
I'm sorry, Your Honor.
The state in their response or in their brief has said that's overbroad and it's not properly before the court. And you really didn't respond to that in your reply brief.
Well, they were primarily focusing on the motion to suppress, was what I got from their brief, Your Honor. And of course, the motion to suppress would be a moot issue insofar as our issue of whether it was a lawful arrest or not a lawful arrest.
Do you agree, though, that if your question is not properly framed and before the court, we don't even have jurisdiction to hear it? You understand that?
No, Your Honor, well, I was not aware of that. I thought the issue was framed in the order itself.
Yeah, well,
But it
maybe
was a
it's
lawful arrest.
because a copy or a page, you're telling us the court that a page of your brief was missing?
Apparently so, Your Honor, because it says it's on the page in there and the issues was there, but it wasn't in that, and it's in a draft that I got that I make notes and I change it and so forth. So apparently it got left out of the brief somehow. I was not aware of that until looking back through it this morning.
Oops. I can't get used to it. Okay.
Any questions? Okay,
Thank you.
thank you. State ready?
Yes, Your Honor. May it please the court, Ben Ball on behalf of the state. Obviously, I'm not Samantha Simpson. She's not able to make it today, so I'll be subbing in for her. Don't hold that against her. But I'll do my best to pinch hit in this situation. So here we have two issues with this certified question, and I think they very much overlap in a way. On one hand, we have an issue of overbreadth. In particular, this question fails to identify what evidence should have been suppressed, and it doesn't go on to deal with the results of the blood alcohol content test. On the other hand, the question is also not dispositive, and I think those two issues sort of intertwine a little bit, but I know we had a discussion about this yesterday, Judge Woodall, where you commented that if the result of answering the certified question in favor of the defendant is a remand, then it's not dispositive. And that's the case here. It's important to note the defendant is not plead to DUI per se. The defendant pled to DUI. So even if the arrest were improper and you threw out the blood draw, the state could still put on evidence of what the officer observed prior to the arrest and what witnesses observed prior to that. So it makes this question not dispositive. So it's both overbroad and it fails to be dispositive, and therefore this court can't reach it. And for those reasons, we would ask this court to affirm the judgment of the trial court and ultimately find that this question is not properly before. Do you have any questions about
Well,
that?
if it's not dispositive, what this court has generally done is not affirm the trial court, but dismiss the appeal.
That's right, Your Honor.
And-
I'm so used to summing up
Yeah.
with that language, but yes, this court should dismiss the appeal, because it doesn't have jurisdiction, because it's not properly before the court, because it fails to meet the requirements for a certified question on multiple grounds.
Is there any, I mean, that's been the general practice of the court in dealing with these certified questions, that especially here where the state agreed to something below and the state's taking a different position on appeal, which under these questions, the general rule that a party can't do that doesn't apply, as I understand it, because it's jurisdictional. But if there's a problem with it, if we say it's not dispositive, so that goes directly affecting the reason for him to, or for this defendant, it's a woman, to enter into the guilty plea based upon what the state and the trial court and the defendant all agreed was dispositive. What effect does that have? Is there another step that, or would this court be prohibited from not only dismissing the appeal, but basically saying the defendant also has a right to withdraw her guilty plea now?
I think the question of the right to withdraw a guilty plea is a question ultimately for the trial court, and I think that often happens in this situation where a question is dismissed. So I think it involves.
I've never seen that. It's never. I know in one case I sat on, and there was a very good, a meritorious issue brought up, but there was a technical problem, and the appeal was dismissed, and the defendant was promptly granted post-conviction relief, and the conviction was set aside and came back up. And this court, after dismissing the appeal, once the certified question was properly drafted, actually granted relief to the defendant on appeal. So, but that's having to file a post-conviction.
That's correct, Your Honor. And that I think that's often what happens in these circumstances when a question is found to be not dispositive, is that there is a post-conviction proceeding.
Well, does this court have jurisdiction to not just dismiss the appeal, but to order that the appeal cannot proceed because it wasn't properly certified, and remand it, or to order the trial court to allow the defendant to withdraw a guilty plea? Is there anything that would prohibit this court from doing that?
I don't know if there's anything in the post-conviction proceeding act that would allow for that. I don't know that it explicitly prohibits it, but I'm not aware of anything in the act that would allow a appellate court to institute post-conviction proceedings instead of a defendant.
Well, I'm not saying post-conviction. I'm saying we dispose of this and we conclude from the record. There may be something in the transcript that makes it very clear that the only reason the defendant pled guilty was to reserve a certified question of law, which this court says that there was no jurisdiction to do that. I mean, if we don't have jurisdiction to consider the appeal, does the trial court have jurisdiction to do what they did? I mean, I know I'm catching you by surprise, and please don't, I don't mean to put you on the spot in an embarrassing way. I'm just curious about if we don't have jurisdiction and dismiss the appeal, which we've been doing for years in cases like this, how does the trial court have jurisdiction to do what it did?
To enter the certified question in the
Yeah,
first place?
to take a guilty plea and say, you have a certified question of law that's properly drafted. and it's dispositive of the case, and I will allow it, and the state agrees to that, and you can enter your guilty plea and you will still get to appeal this legal issue. Now, if we don't have jurisdiction to address it because it's not dispositive, how does the trial court have jurisdiction to do what it did?
Well, the case was properly in the trial court at that point. I mean, it's just a matter of error. It's not, I don't think it's a matter of jurisdiction. I think the trial court, and everyone involved, frankly, while certifying the question, makes an error. But I don't think it's a matter of jurisdiction for the trial court. The case was properly before the trial court. There was a plea entered, and then a portion of that with dealing with the certified question was erroneous. But and that affects the jurisdiction of this court. But the trial court certainly had jurisdiction to accept the plea.
Even if the plea was entered in part because that they were guaranteed a right to appeal a legal issue.
And I think that's something that requires fact-finding in a post-conviction context, as far as whether it induced the defendant petitioner.
Well, am I getting the terminology wrong? I thought was the reason the state has urged in this court on multiple times over the years said we have to dismiss this appeal because we don't have jurisdiction to hear it. It's not dispositive, or the question, even if it's dispositive, it wasn't properly drawn and it's not limited. We don't have jurisdiction.
That's correct.
To consider this legal issue. So how does the trial court have jurisdiction then to take a guilty plea that's intertwined with the right to appeal and says it's properly dispositive of the case, it's a properly drawn certified question, so I accept your guilty plea. If we don't have jurisdiction to hear the appeal of it, your answer is the trial court had jurisdiction to make a terrible mistake, but this court doesn't have jurisdiction to correct it.
Your Honor, I think there's a difference between imparting appellate jurisdiction and a trial court who already has jurisdiction over that case. And I think failure to certify the question properly leads to this court just never gaining proper appellate jurisdiction. This is a real difference in those two scenarios. In the trial court, I don't believe that is a matter of jurisdiction, because the trial court certainly has jurisdiction over that case and over any plea that enters. If
that were correct, wouldn't we have the power to remand it and tell them, y'all botched this up totally. You botched it up. We cannot address the appeal, and remand it for either drawing a new certified question or to withdraw the guilty plea and proceed. But
Rule 37 and state v. Preston and it's don't allow for that. If the question is not dispositive, I mean, either the question is dispositive and you can answer it and that's the end of it, or it's dismissed.
Okay.
Mr. Ball, Mr. Ball, I had a question for you. You seem to indicate that the way the question is right now is not dispositive of this case, because he pled, or she, I'm sorry, Ms. Campbell pled guilty to under the influence of an intoxicant, which was count 2, I believe, of the indictment. Count 1 dealt with the blood result. That was dismissed. So is it your position that had she pled guilty to that and certified the question in the posture that it's in now, then it would be properly before the court?
I think it would be much closer. I haven't, frankly, I haven't given that a great deal of thought. It has occurred to me that it would have been much better situated had that been the case.
So it's not dispositive in the posture that it's in now, because what she pled guilty to had nothing to do with her blood results.
Right now, I think that she'd still have a problem here of the way that the question is phrased. Because the questions that go on to talk about the blood results and attenuation, it just says, essentially, was the arrest valid? I think it has to be more specific and spell that out. What evidence should go as a result of the alleged illegal arrest?
Well, that was kind of my thought when I first read this brief, was we're not really contesting the blood results. We're contesting this stop, this arrest.
Right. I think it's a discrete issue that is, it's not, it doesn't reach a level of being dispositive, and it doesn't address any evidence that would result in the dismissal of the case.
I mean, the defendant's complaint is there was a misdemeanor committed not in the arresting officer's presence. Has nothing to do with even what the offense was,
Exactly.
other than it was a misdemeanor committed not in an officer's presence.
That's correct, Your Honor.
And including TCA 40-7-103, which is grounds for an arrest by an officer, is not specific enough to cover that situation in a certified question. Is that your position?
Yes, Your Honor. I think as far as to deal with the overbreadth issue, I think we'd have to go on to discuss attenuation with the blood draw. And I mean, of course, in turning to the dispositive issue, we still have other evidence even without the blood draw. I think this is a perfectly good issue on a normal direct appeal, but it is not a proper certified question. So I would ask this court to dismiss this appeal.
You finished?
Unless this court has,
Yeah.
has any further questions.
Well, let me ask just one question. I'm trying to think it through. So basically, it's the state's position. Let's just assume this arrest is illegal. And let's assume that the fruit of the tree, poisonous tree, is thrown out. The state's position is there's still sufficient proof where the state could go forward and try to seek a conviction for DUI.
That's correct, Your Honor. And I think that's why it's of note here that this is not a plea to DUI per se, but to DUI generally, because there is still evidence, even if you throw out that blood alcohol, of the observations of the officer and the observations of other people that took place prior to the arrest.
Okay. You've still got some time left if you want to use it.
The only thing I would comment on is the drafting of that issue in that order was with the assistance of the Attorney General for the state. So I'll tell you, his draftsmanship's not very good, any better than mine there. But we would ask that, obviously, that if the court says it has no jurisdiction, then we be permitted to withdraw our guilty plea, and we'll address all those issues one more time. I mean, that was a condition, we feel strongly that the officer violated that code section, didn't have the authority to arrest her and take her into jail and to the hospital and everywhere else.
And what would, it's hard to tell who's talking, but anyway, what do you say are the ramifications? Let's assume that this is an illegal arrest. What evidence must be suppressed?
Well, he had no authority to take her to the jail for the breath test, and had no authority to take her to the hospital to draw blood. I mean, he admitted that she was not free to leave till he finished his investigation, and then he took a warrant after that. So,
Let's say that the trial court had suppressed all of those things, the breath test, her statements, and the blood test. Could the state then go forward after she's indicted and put on other evidence such as the testimony, was it her mother or sister, whoever the related party, or any other witnesses that saw her operate a vehicle under the influence?
I mean, they could call, if the court proceeds that direction, they could call the person that called in to start with. And I think that's probably the only person that saw her drive.
And that would be a question for the jury to determine whether the evidence is sufficient to convict her of DUI.
And also, of course, then we have other witnesses, and I've looked at the video, and the video didn't show me that she was all that impaired. So
Well, those are all questions for the jury. My
correct.
question is this: if the case can go forward, how is this question dispositive?
I'm not sure I understand.
How,
that.
you know, we basically have to find that if we say your certified question is a good one, that is dispositive to the case is over. If we say it's a good question, but the state can still go forward with other evidence, then it's not dispositive of the case. That's the problem we're trying to talk about. At least I've been trying to talk about with the state and you.
I guess the question is, can you use a blood test when she was unlawfully arrested?
Okay, no, I can't. We'll say that. But can they use the testimony of the other witnesses to try to prove her guilt?
Well, they would have to, in my opinion, come back now and get an indictment or something and try to proceed in a different direction, or take another warrant or something like that. I mean, you know, he didn't have a warrant to arrest her to start with. So.
But they assume this case came through the grand jury, or did it got to the circuit court?
Correct.
Okay.
I believe that in other words, if the court dismissed this case, then they would have to, I guess, go forward and get an indictment and try to use other witnesses or something like that. I don't know if that'd be prohibited or not. I'd have to think about that a little bit.
Why would they need to get another indictment when she's already been indicted in count 2 for driving under the influence?
Yeah, it went from the preliminary hearing. It was bound over in an indictment.
And the indictment for count 1 was DUI per se, 0.8 or greater. Count 2, operating a motor vehicle on a road here in Tennessee at a time when they were under the influence of an intoxicant to the extent her ability to operate the vehicle was impaired. And she pled guilty to that. Does she have I noted in the record that you had asked to get her driver's license back, and I guess she's on bond while this appeal is pending. Is that correct?
Correct.
And she was able to get her license back.
I think it's set now to come back up again. They set it off enough to see what was going to happen with the appeal. So we have another court date.
Sure you have.
About the driver's license issue.
Anything else? Thank you.
Thank you very much.
We'll be in recess till 1:30.